makes sense for both of us.
Because I got this here, ready. So on contacts, add new contacts.
No longer, the bond is just there.
You fall leading against the building.
And if they
How does the owner get the building?
they still have to do all the same things.
He happens to be a bonding. So because it's bonded, now your lien goes off the building, it goes off the bond.
But ultimately gets fulfilled.
Tell these guys quickly, Your Honor, the rights is a GC and the value of a sworn statement, so they don't mess that up.
That's nice. That's nice.
Okay.
That's something that actually.
So did you record a lien? Is it in Illinois? Okay.
DuPage County.
I'm sorry?
DuPage County.
DuPage County. Yeah, the county doesn't matter. It's Illinois law. And was it on a private project?
With the doctor office. I think the doctor office.
Okay, so it's a private project.
And that guy, 3 years, it's like around 3 years or some months, you know. So he will be $900,000 all the time in the next
If your last day at work was less than 2 years ago, you probably You're welcome.
This gentleman, Donnie, is the head consul for the Indonesia Trade Council. And we've worked with trade councils before. Because when they bring their equipment over here, there's construction materials. He's got some beautiful materials over there. That's why we're here.
Okay.
They just need to know what to do. He doesn't really know what a lien is, so it'd be kind of nice to like start at the beginning.
Yeah.
Okay. And give some background. Her Honor is a esteemed judge.
Oh, okay.
Retired.
I'm
We're gonna have this
retired,
conversation. And she's had all this experience. Wait to hear what she has to say to help you understand.
Okay, yeah, thank you.
All right, so you're a material supplier.
Yeah.
Okay, and you supply to subcontractors, general contractors?
We're still looking for distributors at the moment, but that's the plan.
If any lien claim is tiny, then doing things on a timely basis.
Okay.
So this would be like a lien on funds. And then in Illinois, anytime money's there can be forever. In other states, it's 120 days. It's all different, like the way the Honor said. And then on government top, state and federal, there are bonds. And the gentleman here before, Your Honor was speaking with, is in that business of bonds, like that. And all the federal remedies are based on the Miller Act bond, which is another thing. So we'll send you this information. And I like that if you want to, for a newsletter for your businesses back home. And we now have some information from Her Honor. She's going to be international pretty soon. You know, she's going to. I don't know how many likes she's going to get. Probably how many people in your country?
280 million.
Okay, she gets at a record. Well, she could. One, she speaks very well. Two, she's very bright. And three, people want to learn. And you know, you have a very great country with great people. And having the opportunity to have you here in Chicago is wonderful. I'd hug you, but it's not allowed anymore. You know what I'm saying? So, but this is good because I think it's important to understand it. And when I first did work for the Italian Trade Council, they had no idea. And we negotiated. If you don't want to go to court, spend time and money, and liens help you by giving you pressure. Because if you don't have a lien, it goes out of business, you get nobody to talk to. You're writing it off. Except in the international world, there's letter of credits and also credit insurance. Things like that. But you know, even those companies want to make sure you protect yourself. They'll like you better because they'll recover from you. So I'm really thrilled that you're able to come by.
I'm excited to know more about the.
No, we're going to give you a whole education a little bit so you can see what's going on. You can certainly visit our website, but I know what you're looking for. I think the most important thing, and kind of what you're saying around is other things. So when mechanic liens and bond claims don't work, we're coming out with a new program, the National Lien Bond, that I've seen with the factors we're using, which is Article 9, secure transactions. So, you know, Her Honor is represented for cases where there are a lot of material suppliers. So the contract there starts with a credit application and it ends up with a PO or something like that. In the credit application, we're going to say, okay, I'm selling you, here's the credit application, assign your rights to me, assign your rights to me with who your account is. So if, let's say you're a supplier to a subcontractor customer, we can jump over the subcontractor and go under Article 9 through assignment of his account to the general contractor. So we were going to lock in the lien. So we named this new program, Lien Lock. Lock in your money like that. And that helps because there's no time limit. There's no time limit. No. That's what you decide to go. Now, if somebody is ahead of you, these are like bank liens. So the bank may have a first lien. You could also then, as long as you tell the bank within 21 days of the first shipment that your lien is for your materials. You can't get all the collateral like the bank has, but for your collateral from Indonesia, even the containers, we can give that person a first lien and move the bank out of the way. So there's ways to really expand credit. And again, we should probably have a conversation with the trade insurance company in Indonesia. We work with EDC, Canadian Export Development Corp, and the U.S. and other trade groups, because they'll want to they stand in your shoes. So this has been very exciting for me to hear Her Honor talk to you, who doesn't know anything about liens, and I'm so glad you're interested in it. Okay, it's really exciting to see because if you have a lien, you're going to get paid. And if something goes wrong, you don't have a lien, you wish you would. It's like the tooth fairy. You know?
Well, now that may be a little extreme. It's not magic. But you definitely have a much better chance of getting paid based on, it puts you much more in the driver's seat.
Yeah, and it's one of the ways that you could mitigate the risk.
Yes.
And it happens, like you said, it happens a lot. The shipment came through, but didn't get paid. So it helps for the supplier.
Yeah, and that's your job. Yeah, to get that done. So the other, I was going to say that a lot of times I'm giving a seminar program like I gave yesterday. I ask everybody, I go, okay, like you have a suit and jacket on. I said, are you a general contractor? And he goes, why do you want to know? I go, because you got to promise me that you're going to get all the secrets that we're going to give you, and you can't use them against us because you got the money usually. So put your things in your ears, okay? And then the second question I ask the contractors that are there, you always get this wrong, Your Honor. You always get this wrong. I get a kick out of this. I say, when you sell on credit to your customer, contractor customer, are you selling an open account or are you selling on some sort of like secured account? They all say they sell an open account, okay? And they're absolutely wrong, as long as they follow what Her Honor said, okay? So she just gave you. This isn't magic, right? But it's something that in America and Indonesia, that we're very proud that we can do. Help yourself.
Yeah.
Okay, help yourself to take the action and be proactive. And that's really a freedom of us in the civilized world, that we don't rely on government. We do have the Her Honor, who is the rule of law, that can tell us when she's right or wrong, and thank God for her.
Always asserts the spirit doctrine as a defense to the claim, but they're saying they followed what the owner gave them, and that's what it applies. The owner, gave them something, and the problem was with what the owner gave them. It wasn't the contractor's money.
Yeah, because architects sometimes they don't really get into the details, or when something happens, they're not completed, the owner doesn't pay enough money for all that, whatever it is. But whatever it happens to be, that's it.
Yeah, it gets complicated. Everything in a construction case is complicated. If you've got a situation where you have an architect who is the owner's consultant, and then the owner also hires the general contractor, and there's a problem, the general contractor is going to say it wasn't defective work, it was a design defect.
Right.
And so now the owner has to figure out, typically what happens is the owner will sue his architect and the general contractor, and then fight whether it was a defective work or was it a design defect or was it both.
Yeah, right. Or a combination, right.
Yeah, exactly.
Yeah, where it goes back and forth. There's like concurrent delay and civil responsibilities.
Oh, yeah. We're really getting into the weeds, Hal.
I know. I have one I want to pull.
Okay.
So I want to get So
you know what free advice is worth.
So I have a client in Texas, and under Texas law, he's got the trust fund.
Yeah.
And the money's supposed to go where it does go, from the owner to the GC.
It's a constructive trust.
Exactly. So then the client didn't follow the time limit that says under the statute. Then, under the indemnity agreement between the general contractor and the bonding company says in the indemnity agreement, in addition to the statute, I don't think it is a statute that we're talking about, because the statute's not mentioned. It says, in our relationship as surety and principal, I'm having indemnified me, and one of my requirements is that you promise this clause that these are trust funds. In other words, it's not a statute, it's in the indemnity agreement, therefore it's in the language of the agreement, I believe, okay?
Right.
And so what happens here is that the general contractor did not keep the funds in his trust. The bonding company writes a letter to the owner and says, before this happens, it says, the owner pay me because there's a default. The general contractor is default by the owner. Then the owner pays the contractor because he leaned the job, he gets the lien off. I mean, wait a minute. You should have, somebody called me, I'm the subcontractor. I'm the trust beneficiary. None of you guys did anything. And spend it to GC because he's in defaulted bond and a trust fund. You said that to the Illinois judge. The Illinois judge agreed with you. Issued a permanent injunction. You took that to the bankruptcy court of Louisiana, and you're saying that that contractor now, okay, has done enough wrongdoing to change it from an 11 to a 7. And it says in both these jurisdictions, you say that we are owed the money and you're liable to me. That's what gives you the right to make fraud against you. But I was defrauded first. You know what I'm saying? In other words, the general contractor took the money and diverted it. The surety could have stopped it, whatever. But now the surety admits that they owe me money. That's how you got the injunctions in the pleadings. So that admission, I'm guessing, means something to the Illinois judge that made the ruling based on it. And the federal judge with bankruptcy is about to change it from 11 to a 7 because of the misconduct that occurred.
Okay.
So therefore, my client can show. It gets a little crazy. Listen to this one,
It already sounds crazy.
Yeah, but listen to this is the best part. You can file in Texas I'm not a Texas lawyer, so this is what they tell me. A constitutional lien if you have a contract with the owner. We didn't have a contract with the owner. It's one exception. Like in your case with Woodstock, how do you make the sub have by law a contract with the owner? Sham transactions. So if you can see that the GC took the money, the owner paid the money after he terminated the GC wrongfully because he knew he should have paid me, okay? And the surety company paid nobody, knowing that they had an obligation to pay me and the minute they had the obligation. So we got all this evidence of everybody responsible to my client. I call that a sham. All three of you are shamming my client. Okay, the bonding company didn't make the damages. They didn't do their due diligence to pay me, and yet they say they owe me the money. When did you make that decision? You owe me the money. I don't got the money. Okay, you say you don't owe me the money. Okay, so I think that's a sham. The sham is between the owner who made me go to back work and finish after they terminated the contract. They said they were going to hold the money back. They actually said that in letters. They said, "You're not owed the money, GC. You owe him the money. We're holding it back." Then they paid him because he leaned the job, and then they paid him the money that belonged to me.
I don't understand all of the pieces and parts that you just said. However, in Illinois, I mean, it kind of gets back to the sworn statements to a point, but once the owner is on notice of a claim from a subcontractor or a supplier, if the owner does not hold on to those funds and pays them out, the owner's liable for payment.
For double payment.
Right, exactly. That's when an owner has to pay twice.
Right.
I mean, that's the whole point of requiring a sworn statement. Or if the subcontractor has served properly served their lien notice and recorded their lien, and then the owner still goes ahead and pays the general contractor.
Right.
The owner's on the hook.
No, you're right about that. You're right about that. I don't know Texas law well enough to know that, but that logic would seem to apply.
But I don't think you even have to go so far to prove that it's a sham. It doesn't matter. The law in Illinois just says that.
Well, the reason the word sham is important is that the client didn't file constitutional lien timely. So you can file because the statutory lien didn't do timely, let's say. Constitutional lien is longer. If you have a constitutional lien, you have to have the word sham in there. Just
Oh.
saying. So it sounds to me like it's a scam.
That's above my pay grade.
I know, but you're right, Your Honor. It's like right, and I don't know either because it's like I'm not. You want to talk to the judge?
It's like a lawyer's going to cost more than what I'm
In
owed.
some cases, that's true.
Yeah.
Yeah. In a
So
lot of
5 or
cases.
10 grand.
No, you're not. It doesn't make sense.
Yeah.
Yeah.
But I want your info.
Well, so you want his info
She's
because
a judge.
I'm just.
You're a judge?
I'm a retired judge.
Wow.
And so I'm just here to
I
talk
thought you were
about.
joking.
No. The reason is I'm here is because I did work on. I heard mechanics lien cases, and so I can answer questions about the law, but I don't give legal advice.
Where were you at? Where were you based?
I'm in Cook County.
And like what level of courtroom or
Well,
general?
so okay, no. So there's in Cook County, there are 3 courtrooms that are dedicated mechanics lien case courtrooms,
Wow, I didn't know.
which is part of the Chancery Division.
Chancery, yeah. I
Yeah.
know that.
Yeah, so that's
Sort of
right.
like business, right? Chancery.
Well, yeah, sort of.
It's like it catches with the other, like family. It doesn't fall in, and it goes in
It's
chancery.
its own world, special remedy.
And it's
Chancellor's like the real, they're equitable.
yeah,
That's
it's
where they are, they're equitable.
right. It's cases involving equitable claims, as opposed to here. Chancery does deal with money damage claims.
Like instead of having a bond, can you like have a trust account at a bank instead, like an escrow account? Like
For
Are
what
you talking about
purpose?
for the union or for you?
no, for me.
So what do you need?
purpose?
So like say you have a piece of property and there are a lot of different people that have ownership of it and it's about to be sold and maybe you're the administrator or whatever. Normally if everybody doesn't waive their rights or whatever, you have to post a bond. Well, instead of posting a bond, could you do like an escrow or trust account in lieu of a bond?
It's not my area of expertise. You would need to talk to. It sounds more like you need to talk to like a trust and estate attorney.
Okay, here's another question. Suppose, well, you said it's not your area.
Not really. What I deal with is like you're a carpenter. You don't get paid. You have a right, a lien right against the real estate on where you did the work.
That happened to me once. Not that I didn't get paid, but I got paid a month and a half late. And then I asked them, I was like, well, aren't you going to do something for the inconvenience? Or these videos? And they were like, no.
Well, yeah, people get paid late all the time.
That's not fair.
It may not be fair, but it's life.
Okay. Okay, so what if you have a written contract where someone has told you you're definitely going to be working on this project? Definitely.
Yeah.
And then you take the time off and put it in your schedule to work, and then when you get there, they're like, oh no, we don't need you. Since that's not only just an oral contract but written, what can you do about it?
You probably have a right to enforce to enforce the contract. Whatever they said they were going to pay you for a period of time. I assume it was for a period of
For the
time.
length of the project, yeah.
Okay. You'd have to sue. I mean, that's the problem. You've got a contract. You probably have the right to enforce it. But the only way to enforce it is to go to court. And then the problem is you got to pay a lawyer to do it.
Right. So you gotta wait.
Yeah, you do. It's balancing, for sure. No, I was. I'm retired.
God bless you. Good for you.
Thank you.
Mechanic lien division. Okay. So she knows more about construction law than you. This guy's got an ingenious idea. It's going to work.
You thought I was a real model, didn't you?
This guy may be able to help you too.
Yep. Okay.
You know what he materials for?
What?
The United States and Afghanistan.
Is that right?
Yeah. You guys should talk.
And
By the way,
Afghanistan.
you guys should talk.
I'll talk to anyone. Hi, what's your name, sir? Pardon me? Saram. Saram? Nice to meet you. Charles Stevens. My business is a little different. Okay.
I was going to ask you what your business is.
Well, what he knows is just a small sliver. So I'm gonna just focus on that. I deliver materials. I'm the purchasing department for developers, contractors. I buy all their materials. Okay, I buy them and pay for them. I deliver them to the job site. My runners deliver it to the job site, and at that point, it's transferred to the crews who actually install the materials. So I'm toying with the notion of marketing the idea that we provide a higher level of security, because if the materials are stolen, then it's a contractual issue. Once I deliver it and show proof it was delivered, it now changes the character. It's now a theft if it's stolen. You see what I mean? So it's asset management from my investors and developer standpoint, how they're managing materials with general contractors. It's a little more secure than, and there's a criminal aspect to it as well. So there's more leverage on the general contractors and people like that to not steal the materials.
Is that a big deal?
Stealing materials?
Yeah.
Is it a big deal?
I mean, it would be a big deal if it happened. I think my question is more, it happens that often?
The way general contractors and subcontractors think of materials, when I buy for you, I buy for me. It's that pervasive. Let me give you a real life story. Chino Hernandez, I worked with him for 5 years. He did work for me. I gave him a vinyl siding job. 70 financial stakeholders aren't watching, and they know they can get away with it because they're going to obfuscate and confuse the fact that they're buying framing screws. They look like screws if you didn't know what they were on the Home Depot bill. You see what I mean? But I'm a developer. I mean, I know what you don't need 4-inch screws to apply vinyl, you know? So I caught him on it. I haven't done business with him since then. But that's the attitude. Typically, a GC will mark it up anyway. The subs will mark it up too.
Oh, yeah, but that's different.
It's a little different. But the theft aspect of it. I had someone steal 27 boxes of vinyl flooring. You know how much that had to weigh? You know, each box carrying it out, 27 boxes of vinyl flooring. You know, it's really since internet came, the theft got different. They used to come in and steal your copper. They don't want to do that. They'll do it, but they don't want. That's not where the money is. The money is in anything that's in a box, because they can put it on eBay or Craigslist and sell it at close to retail. It's much more than that much copper. You see what I mean? So the game has changed. So we have to step up our game to combat this. So that's my comment. We're pay on delivery. You don't pay for the materials until they're at the job site. And you don't give them deposits. Why? Tell us at the job site it's not needed. So you don't have to give a GC 20%, 25% to start a job. Make sense?
Yeah. Most of what I see are much bigger projects.
Much bigger.
Yeah.
Much bigger. But
So, I mean, I see what you're saying in the context that you're talking about.
But the issue is the same. They steal there too.
Well, they very well might. It's just not, it's not the same setting.
They're not stealing
And-
steel beam.
Right, exactly.
They steal time, which we don't manage to that, but we manage to use of materials. And what I've just given you is kind of like a tip of the